So shareholder primacy is the term generally given to the basic proposition that's been unchallenged really for quite a while, that the principal job of directors is to make the pie higher for the shareholders. So that the job of the directors is acting in the interests of the company, the best interests of the company, is really about shareholder wealth maximisation. Now that's not always been an uncontroversial view. And if you go back to the 40s and the 50s, for example, there was a much more managerial type of conception of the company, but certainly from the mid to late 70s on, that view has grown, and it's now largely accepted that it's the principal job of directors in acting in the best interests of the company. Your basic job is to maximise shareholder wealth. So the challenge that we see, and we see it in a number of places, you see it in conversations, you see it on blogs, but we've called out in particular in the report two very stark examples, is to the, if you like, the raw simplicity of that basic conception. So the basic idea has been, look, that's the job of directors. And if there are other things that are relevant to ensuring that the company is a good corporate citizen, which aren't naturally taken account of by directors, in ensuring that the company has a good reputation with customers and with suppliers, etc., then that's the job of other laws. So employment law, environmental law, financial services law, financial offering law, all of that stuff. That's the job of other law. The job of directors is to make money legally within those constrictions. And what we're seeing in the UK is a nibbling away at the edges of that. So the core duty of directors now in the UK is to act in a way which will promote the success of the business in the interests of all shareholders, compulsorily having regard to a range of matters which include the interest of the environment, but the desirability of maintaining a good reputation with suppliers and customers, the interests of employees. Now all of those sound fine, and in many cases directors will do that. Directors will say, for us to be able to continue to make money for shareholders, we need to have a good reputation, and we need to be able to do business, repeat business with customers and suppliers and employees, and we need to be seen to take care of the environment. So it's all part of acting in the interests of the company. But now in the UK, they're required to have regard to those matters. So what's the impact of that? Well, some people just say nothing, because good directors do it anyway. But what we do know is that when you put words into a statute, then lawyers look at those words, and lawyers will say to their clients, in more circumstances, there is something that you could complain about here. And so what we think is likely to happen is that there will be an increasing number of challenges to the decisions directors made on a basis which is much more like the basis you see in judicial review, where ministers, for example, are challenged not because of the substance of their decision, but because they didn't have regard to the right factors, the mandatory relevant considerations. And you can see that that might arise in the UK, where, for example, there is an unpopular decision to sell off an asset, or to wind the company up, or to make a bunch of redundancies. And the directors might ultimately be able to say, look, we made those decisions because our primary goal is to ensure the long-term success of the company for the benefit of shareholders. But the challenge will be, but did you have regard to the interests of employees? Did you have regard to the desirability of maintaining a good reputation with suppliers who are no longer going to have this business? And if you can't show that you did have adequate regard to those matters, then maybe the decision can be challenged by, for example, activist shareholders. So, look, it's too early to make predictions, but you can certainly see that directors are going to be concerned about what all those words mean, and the immediate impact will be more expenditure on lawyers, because good boards are going to want to make sure that they're safe. So actually there'll be an increased focus on ensuring that you can prove after the fact that you did the right thing, which is completely contrary to what the director community is saying, is we actually need to focus on the things that are important to business. So that's the UK challenge. An even starker challenge closer to home is from Rob Everett. I mean, you've got the Chief Executive of the Financial Markets Authority saying, literally, the Milton Friedman model, by which he means really the shareholder primacy model, is broken. And in fact, it never worked anyway. And so his attack is a very direct attack on the simple conception that the job of directors is to act in the interests of the company, meaning make money for shareholders. And he's saying, actually, the phrase social license is overused, but that's really what he's getting at, and that to fix that, you need to look not just at whether the laws that relate to companies generally need to be tightened, but you actually need to go right to the heart of the company law and think about a different conception of the core duties of directors. So there is a significant potential challenge there, and our expectation is that that's not going to die a death, that the zeitgeist is one where there is a real appetite to explore these issues, and Rob Everett has clearly gone out there and said we should be exploring it, and the UK has sort of led the way on one way of doing it. So it really is a case of watch this space.